A very good evening to all our viewers. Thank you for making time and join us on the agenda this week. My name is Toivan Jebela, your host. Tonight on the show, we are discussing the issue of the Supreme Court ruling on or related to same-sex marriages. And to help me unpack again this conversation is Dr. Panduleni Itula. He is President of the Independent Patriots for Change, IPC, as well as Basilius Dyakugha. He is the Ombudsman of Namibia. Doc, thank you for making time.
Thank you very
Bas,
much.
thank you very much for making time. Yeah, wonderful. Thank you.
Yes, thank you for having me.
Yeah, wonderful.
And thank you for your viewers.
Yeah, absolutely. We'll start with Dr. Itula, really. Your party has pronounced itself finally on this issue. There was a statement issued. If you can summarize in not so many words what sort of the party's stance on this ruling is.
Right. Thank you very much indeed. Our party has consulted its National Council of Patriots, which is the equivalent of the Central Committee in other parties, and the Steering Committee, which deals with urgent issues. And we have peruse the 77-page document and make relevant references to previous judgment of the Supreme Court, relevant references to our own constitution, and relevant reference to relevant statutory provisions and also common law principles. And on that basis, we manifestly stated that the Supreme Court erred patently on the basis which they rely on to make the decision. It's basically the ratio decidente, or rather the basis upon which they made the decision is manifestly wrong. And at the same time, and that is because they relied on a foreign jurisdiction of a lower court's decision in a case remote, it's related but not essentially the same. And they also, in so deciding, went against their own common law principles pronounced in the Supreme Court and in the High Court as well, which clearly stated that where there is a reliance on foreign precedents, those should be treated very cautiously, especially when there is differences in the constitutions and the wording of the constitutions relied upon. And there is a difference between the Namibian constitution and the South African constitution, specifically referring to the issues that they actually ventilated in the judgment.
Yeah, so just a quick follow-up again, Doctor. So for IPC, the issue is more the constitutionality or legality of the judgment itself and not very much the same-sex issue. Is that...
The issue is the basis upon which we said that they put the cart before the horses. Yeah. They used a decision in South Africa which involved same-sex couples, which constituted that sex marriage on the basis of civil union of the United Kingdom of 2004. The same union Act in South Africa of 2006 was the basis upon which they felt that they've got authority to dissolve the marriage. Yeah. Now, in Namibia, we don't have a similar provision in our statutes. Yeah. And we need to be very careful as well on the basis that the Hague Convention of 1978, which basically is the Convention on the Recognition of the Validity of Foreign Marriages, has never been ratified in Namibia. And although, bearing in mind the provisions of Article 144 of the Namibian Constitution, that article puts on par the constitutionality or the Namibian Constitution and the supreme legislative sovereignty of our parliament. And it does that disjunctively by the use of the word or, meaning that international conventions, basically saying general rules of public international law shall be applicable in Namibia unless contradicted by the constitution or parliament. And the use of or there puts the Constitution and Parliament on par, consequently meaning that they recognize the sovereignty of our Parliament, and until such time that the Parliament contradict that, then it will be applicable. And that is taking away the sovereignty of the people of Namibia, because the will of the Namibian people is in Parliament. And also at the same time looking at Article 81, Article 81 also says that the Supreme Court decisions are binding on everybody in lower courts unless they themselves reverses it, or again is reversed by an lawfully enacted provision of our Parliament. And the use of the disjunctive there says that the Namibian Supreme Court and the Namibian Parliament are on par in reversing a judgment or a decision of the Supreme Court. And those are the essential critical issues that needs to be taken into consideration as well, in addition to the due respect misinterpretation and error in misinterpretation of the provisions of many of our laws and the Constitution, especially Article 14.
Yeah, we'll unpack those recourses that are still available as the show goes. Mr. Dyakugha, you were quoted in Namibian Sun this week saying that your office is essentially duty-bound by that ruling, and that those affected by this ruling can actually approach your office and seek assistance. If you can expand on that.
Yeah, maybe before I get to that in detail, I have to make it clear to our viewers that I'm here to represent my office as an ombudsman, and maybe to a certain extent as a lawyer.
Yes.
You can ask legal issues. I mean, Dr. Itula is also a lawyer. We can help to clarify some of the legal issues.
Absolutely.
But I want to stress the point that in my position as ombudsman, in terms of Article 93, I cannot discuss the ruling of the Supreme Court.
Okay.
I'm actually not permitted to get into the ruling of the Supreme Court judges or the High Court, even the judicial officers in the Magistrate Court when they do their work as presiding officers. I'm actually go to the extent only on administrative matters, which simply means delay in delivering judgments. That one I can inquire.
Okay.
Therefore, we have to be clear on that one. And secondly, I think I'm not going to really discuss whether same-sex marriage should be legalized or not, because we have, it will be probably not the appropriate to do so, because some of the sections of the populations that want to champion that right are not represented here. And I think I'm also not qualified to discuss that one, although I have done extensive research on same-sex marriage, because you must remember my background. I was in the human rights field for a very long time, even at the Human Rights Council. Yes, the statement I made in the Namibian Sun is not controversial. It's just simple. Ombudsman's role is really to stand there for any member of the community or inhabitant in Namibia to protect their rights that are recognized. And how are rights recognized? Rights are actually recognized in three ways. In the Constitution, by Act of Parliament, and by case law. And case law is actually simply judgment from the superior courts, High Court and Supreme Court. So this one, as we stand now, as we speak now, it's now there and it's not yet challenged. So it is in the eyes of the Namibian setup, it is now a case law, it is now a law. So, and Article 91 is very clear that the decision of the Supreme Court must be binding on every person, including individuals, and institutions. So now, as an ombudsman, if these couples one day now go to Home Affairs office and Home Affairs still drag their feet not to register their marriage as per the judgment of the Supreme Court, this is basically what I said. They can come to my office and we will see how we can assist them at the office of the Ministry of Home Affairs. So it's not to say I will go to court and enforce I don't enforce judgments. Yeah, that's not my role. So that's simple, the role of the ombudsman.
I understand. No, I understood the context from the day you said what you said in Namibian Sun. I understood it exactly that way. But so it's good that you sort of expanded on it more for the sake of the viewers. Dr. Itula, I think a lot of people are surprised by the IPC stance. People look at you, of course you are the leader of the party, but the party itself is a conglomeration of members. So even if you had a different position, I suppose in a setup like that, you still have to listen to other party members. But people see you as a liberal. They see you as this man who has been in the UK for so long, and the UK is a free society, it's a liberal society, and they thought of all parties, IPC will probably be the one that will be taking a stand supporting this ruling.
I think we need to be very careful. IPC's leader cannot be defined by the perceptions of other people. And the environment in which I have been brought up in the UK and Namibia itself hasn't taken away my fundamental ability to make a concise judgment and guide the party accordingly. We need to understand that IPC members all believe in the rule of law, which is fundamental to the Namibian constitution. And judges and administrative bodies such as the Supreme Court has got an obligation under Article 18 to comply with common law, relevant common law, and any relevant legislation imposed upon them. And in this regard, all administrative power executed derives its legitimacy from being lawful based on the rule of law. Where an execution of administrative power or authority is contrary to the rule of law, then that is to be objected upon. In a judgment of the Attorney General versus the Minister of Finance and others in 2013, it was clearly explicitly stated that precedences of South Africa should not be followed where there is manifestly a difference between the statutes. Now, we don't have a same-sex law in Namibia which allows for same-sex couples to engage in a union. In South Africa, they do. And notwithstanding the principle, the Supreme Law made reference at their paragraph 82 of the judgment that the well-established principle of common law, and made reference to it to say that a marriage is celebrated in the loci or in the jurisdiction where it was contracted. And they relied on the Hague Convention. Now, that is not a common law principle, and they refer to a case of a High Court in the Western Cape, which is not even on par to our Supreme Court. Now, they themselves also referred, and this is by His Lordship, Deputy Chief Justice Damaset, where he says that when we are interpreting the provisions of the Constitution, we must have regard to the express or implicit intention of the framers of the Constitution. And it's our view that the framers of the Constitution, when they referred to the gender in our Constitution, had in mind heterosexual couples. At the same time as well, when the South African judges made the decision they did in respect of adjudicating on the divorce, they made that decision conscious of the Same-Sex Act. Now, when you look at many of the provisions of the Namibian Constitution, the Article 4 in respect of marriages and citizenship, and then Article 14 of the Namibian Constitution, they refer to men and women. Now, we need to be very careful also in Article 10, sub-article 2, which refers to sex. In the South African Constitution, in the Bill of Rights, Article 9.3 refers to sex and also sex orientation. So there are two distinct grounds upon which discrimination is prohibited in the South African Constitution, which is not the same in the sex that is referred to in Article 10.2. In Article 10.2, the framers refer to the gender distinct differences anatomically rather than the psychological, mental, or environmental sexual orientation of the people. Now, what has been expressed by the IPC is not Dr. Itula's view. It's a collective view. We believe in that collective view. We consulted the National Council of Patriots, which is the highest authority for issues of this nature, and the steering committee. And the IPC steering committee meets every Monday to consult on issues. And the National Council of Patriots has been consulted by a round-robin approach, and they all were in support of that. And now, when our members have taken their oath of membership of the party in their membership card, we in Article 3.11 states clearly that we will uphold and respect and implement the provisions of the Namibian Constitution, including the rule of law and including Article 18. And we know that in Article 81 of the Namibian Constitution, where the rulings and the decisions of the Supreme Court are binding on everyone. Yes, they are binding on us, provided those rulings are legitimate and complied with the rule of law. Now, there's a principle. The law, however wrong it is, shall still be obeyed. And therefore, whoever is supposed to be falling under the judgment of the Supreme Court should obey it until it's set aside by a competent court. Now, in order to set it aside, you'll have to approach the Chief Justice. And they have done that in the previous sessions, and they've done that. The Itula case attempted to do it as well. But it's up to the Supreme Court Chief Justice to make that decision whether they will revisit their case again. However, the provisions of Article 81, the heading is finality of the Supreme Court judgment, meaning that this is it, this is final, no other authority in this. But as I said, there is a disjunctive: Supreme Court reverses itself or the Parliament. And that places these two institutions at par. Now, if Parliament is persuaded in terms of Article 63, sub-article 2F, where they are able to initiate a referendum or they are able to initiate a law, it still has to go to the Cabinet's Legislative Committee, which is chaired by the Minister of Justice, before it can actually be promulgated as a referendum or an act of Parliament. So we have to see in those ones that the likelihood of the Supreme Court reversing its own decision is remote. The likelihood of Parliament coming and promulgating a law against sex marriage is also remote. And the same applies to a referendum. However, we need to be able to say this, that if we relied on any international provision as by Article 144, that article says that provided, and in recognition of sovereignty of the Namibian people and the Parliament, that such does not contradict any other laws of the Republic. Now, the judgment contradicts the Criminal Procedural Act, Act 51 of 77, in that it legalizes sodomy effectively, and it also contradicts the Domestic Violence Act, which says that the subjects of domestic violence must be of different sexes. It also violates the Child Care and Protection Act as well. And the judges made a reference to say in their paragraph 83 that the word spouse and marriage were not defined in the Migration Control Act. But it's defined in the Constitution, is defined in marriage in the Child Care and Protection Act, right at definitions in Section 1, which says what is marriage. And it refers to marriage contracted in terms of any laws of the Republic of Namibia or any other country where those laws of any other country are recognized in Namibian law. Now, the civil union in South Africa is not recognized in any Namibian statute or the Namibian constitution.
I hear you.
So the decision is purely based on a legal analysis of what the decision was. The stare decisis as well, the decision must stand. The decision that they said should stand and we should rely on it, where they referred to our common law, is not our common law. It's a foreign common law. Common law is applied vertically from the top to the bottom and not horizontally across jurisdiction. And this is where, respectfully, our lordships add. And they add very cleverly. And you'll need to analyze from paragraph 82 up to paragraph 90. And in paragraph 89, the last sentence, they say, in Namibia, there is no statute that precludes the recognition of same-sex. And there's loads of it, even in our constitution.
Wonderful. Wonderful, Doc. Before we go for the break, Basilius, so in your case, and I know that you are trying to walk a very tightrope here, you're trying to be very careful, but if anyone was to approach your office saying, we went to Home Affairs and they're saying, they're still saying no, what recourse specifically can you take to assist those people?
Well, it's a good question. But you see, we have operational procedures, and it's based on law. And the Constitution and the Ombudsman Act is just one and the same thing because it's a copy and paste from the Constitution into the Act. We just actually want public officials to act fairly and not to discriminate any person. That is based on the provisions that Dr. Itula talks about, Article 10 and Article 18 of the Namibian Constitution. That is basically on the administrative fairness of public officials and institutions in Namibia. So in their business of delivering services and serving Namibian people, or the inhabitant of Namibia, because you may find some people who are also domiciled here. They have to act fairly, and that is basically what the Office of the Ombudsman does. So we have to find out on what basis are they refusing to deliver those services to those people if the law is clear, And in this case, you must remember that there is freedoms and rights. Now, we based our understanding of these two concepts on the Constitution. And if the rights is not recognized in the Constitution, we don't really go much into that business because we don't recognize rights at our office. We just protect what is already enumerated in the Constitution or in Act of Parliament or in international instrument that we are party to. And the institutions that actually have the mandate to recognize rights are clear. It is Parliament, the Cabinet, the court. Those are the institutions that recognize rights in this country. So for us, it's really to make sure that what we have on statute, and by the way, we also have something what we call unwritten laws, which is common law, of course. So we just look at that, and then we want to enforce those ones with the relevant government officials.
Yeah. So would it mean, for example, that at the most extreme, can you, for example, take the Minister of Home Affairs to court, just theoretically speaking?
It's difficult to say because you see, I have told the staff in my office when I get when I was appointed that my understanding of this office, we are impartial. And the Constitution is clear on that one. So when you come to my office to complain, you are not my client. You are just a complainant. So I have to listen to what are you complaining about and then go and hear the other side.
Yeah.
So on that basis, it's difficult to answer your question definitely because it depends on what will the Ministry of Home Affairs ground will be for refusing.
Yeah.
So if their refusal is based on legal basis, then obviously I cannot force them to break the law or the rule on which they are basing their argument against surrendering that particular service.
Yeah.
So that's actually how we operate. I'm impartial.
There's only one point.
Yeah.
In Section 26 of the Immigration Control Act, they are obliged not to recognize the application if, in doing so, it is against any other laws of Namibia. Now, if they recognize that on grounds of union of same sex, that will be against the Criminal Procedure Act, it will be against the Child Care Act and everything else. So, notwithstanding the compliance with the judgment, the beauty of the judgment and the order is this, that the order has got no time limitation. So the Home Office can refuse them forever because the judgment doesn't say within 30 days or 2 months as usual. It just says they should recognize this one as a spouse. Fair enough.
But if you show up, because the other way around can also apply to say, okay, since there's no timeline, it doesn't mean that if I show up tomorrow, that you cannot assist me. So what happens in that case?
Well, the order goes against Article 18. Administrative bodies must comply with relevant legislation. Their relevant legislation is the Immigration Control Act. Section 26 thereof, I think Section 26 3F, contradicts them from acknowledging that spouse if it's offends any other laws in Namibia. And also if it's against public policy, if it offends the integrity and dignity of the Namibian people too. We've got a very complex monster here. And that complex monster needs to be handled with absolute clear minds. We need to depart from our emotional mind and go into our reasoning mind and make sure that we approach it paying attention to all the relevant instruments and factors that needs to be attributed to.
Absolutely.
I can assist you.
Yeah, please.
Dr. Itula, you know, the other law is the Immoral Practical Act that also clearly says no sodomy. The recognition of foreign marriage, how the legal principle work is that if it was for the couple that married in a foreign country, by the time that they married in a foreign country, it would have also be legal to marry in the Namibian legal system. That is actually the basis of you recognizing the foreign marriage. Because there is a case, I just don't remember the citation of the case, of Namibian situation where couples went to Nigeria and married there. But what happened is they wanted to evade the Namibian legal system because here, for you to get married, you need to meet certain requirements, which is the age limit. But they went to marry in Nigeria. So when they came back to Namibia, they wanted to register their marriage. That marriage was nullified. So you can look at that case, it is there.
So it wasn't same sex, it's just the age?
It is just the age. It was not the same-sex marriage, but it's just a normal. So what about then, because when you talk about marriage, we talk about any marriage. So you need to meet the requirements of the domestic law first, before you can regard it as legal in your domestic.
In the foreign.
Yeah. Let's go for a quick break. This conversation is getting very, very exciting, but we'll be back in a moment.
We are so excited to be kickstarting your morning with the entertainment. Everything was happening during this past weekend.
Yes.
Exciting news.
Wow, no, she was killing it already.
In my opinion, I don't see anything wrong with him serving the full term.
As well as keeping you informed on the issues that you need to know happening in and around our country.
To another exciting episode of Ironggo Talk. We bring jou Letiz weer en vertel ook vir julle waar die vis julle mondstuk gaan byt.
The conversation continues on the show. Doc, I have been arguing one thing for the past 2 weeks because I also seem to think that there's a lot of misinterpretation of this ruling because people keep talking about same-sex marriages and the recognition thereof. But my interpretation of that ruling is that the court simply says that a same-sex foreign spouse to a Namibian person must be granted the same rights in terms of the immigration laws of the country, in terms of domicile rules, if you can stay here, because there are people who are married to Namibian people, same sex, and they are living in the country on study permits, they register at NAST or UNAM just to live in the country with their spouse. And what this judgment does now is to say, you are now going to be issued with letters that Dr. Itula's wife, who's of British descent, can be here in Namibia, that in that sense that they're equal on that ground. It doesn't really say that same-sex marriages are recognized.
No, the judgment did not, in essence, usurp the legislative powers of Parliament. It did not say Namibia now recognizes same-sex marriage. The judgment on the basis of paragraph 83, in the absence of a definition, in their view, of the word spouse, which was the first word, spouse. There is no definition of the word spouse there. And there is no definition of the word marriage. And they went on to say in Namibia, in their paragraph 89, there is no statutory provision that precludes recognition of spouse and marriage. It did not say that the foreign constituted same-sex marriages shall now be law in Namibia. All it said that recognize this person for permanent residence as a spouse of a citizen who contracted their union in a foreign country. And they relied indirectly on the Hague Convention of recognition of the validity of foreign marriages. Once you recognize the validity of the foreign marriage on the basis of the foreign laws, you now need to look at your own laws in the country, whether such is acceptable. Is there an equivalent? In fact, in their paragraph 85, they says, in paragraph 20 of their judgment, they says that the central issue in this appeal is whether the refusal is compatible. The refusal of the same marriages in Germany, in South Africa, is compatible with the Namibian constitution. Yeah. And in looking at the Namibian constitution, one is reminded of the judgment in Attorney General and Ministry of Finance and others when His Lordship Damas have stated that when we are interpreting the constitution, we must bear in mind the express and implicit intention of the framers of the Constitution. When we are interpreting the word spouse and marriage in our Constitution, we must bear in mind the intentions of the framers of the Constitution. The framers of the Constitution were, I believe, aware of homosexuality and same-sex marriages. That was in 1990. So they were aware of that because they would have been aware as well in all religious sectors, including are Muslims, where Muhammad said that if you find anybody that practices what Lot and his people did, kill them, etc. So they were away from that, coming from a predominantly Christian society. And we need to be very aware as well in Article 1, when we talk about a secular society, secular state, it doesn't mean that we are not believing in churches. It merely means that the state is not going to recognize a religion, neither is it going to use taxpayers' money to support any one religion. And that contradicts as well that when the parliament starts, they all go into prayer. And one wonders what that actually means when they go into prayer, whether they are emphasizing, they pray in the Christian norm, whether they are emphasizing that. So the judgment in itself does not recognize same-sex marriages. It recognizes the partners in the union as spouses. Now we need to be very careful that there is a difference between the object of Article 10 and the subject of Article 10. The subject of Article 10 is the people in the marriage, but it's not the marriage itself. Marriage as an institution is not a juristic person because it does not sue. Now what they did is recognize the subjects in the marriage and implicitly recognize the object, which is the marriage. The object is only lawful in the jurisdiction in which it was contracted. Now it's up to the principles of lex fori, that means the forum in which the decision now is going to be made, to apply its own domestic laws. Now domestic laws cannot be inferior to any international law or anything like that in terms of public law. It can also not be inferior to any laws of other jurisdiction. Otherwise, we deny the Namibian people's will in terms of Article 45, which says that we are represented in our parliament and we are represented there, and they make a decision as the will of the people. In terms of public policy, the will of the people is the onslaught that we've had from all quarters of Namibia. That what they almost phrase as the repugnant manner in which the Supreme Court denied its own Supreme Court common law, judge-made law, which in the case of the Attorney General they did, and also in the case of Kawesa as well, they did Kawesa versus the Home Affairs. Everywhere else, the Supreme Court said, we are not going to rely on foreign judgments, we must rely on our own. And we need to be careful how we interpret the Constitution as well. So there is a bit of that problem down there.
I understand. Basilius, one of the arguments, and now I'm asking you as a lawyer, not as an ombudsman, one of the things that seem to have angered a lot of people as far as this judgment is concerned is that the judges seem to have relied on the constitutional provision of equality and not on the laws, or on what the actual parliamentary acts say. I mean, what kind of precedent is that setting to say, yes, the Act of Parliament says this, but because it seems to contradict the principle, the framework of the Constitution itself that says we are all equal, somehow the Act of Parliament doesn't matter anymore, only the Constitution matters?
Yeah, I think I need to clear one thing.
Yes, please.
You know,
I'm speaking as a layman.
When the courts adjudicate on matters, they just focus on what is brought before them. Yeah. In this case, as you correctly said, and Dr. Itula also, that they did not really focus on whether to recognize same-sex marriage in Namibia. They focus on the issue of immigration issues, yes, the domicile issue. So therefore, I tend to disagree that they made this ruling based on the constitutional provision. I read the judgment. They mentioned the provisions of the Constitution in passing, but I think the emphasis in their judgment, if you can just read the summary, then you get to the point, is Section 2 of the Immigration Act. section 2, subparagraph 3 of that section. So it is not really a constitutional judgment, this one, in my view. Therefore, I think Namibians are still safe in terms of maneuvering to shield any values they want to protect in terms of the subject matter of which is now hot of the same-sex marriage. But because we need to understand that if should it have been a constitutional judgment based on a constitutional provision, then that would have been probably, we have reached the end of the road, because even the popular vote cannot overturn that one. Yeah. Because it's a constitutional provision. Because we are a constitutional democracy. So Parliament cannot enter the arena where the court has made a ruling on the provisions of the Constitution in terms of their interpretation, and then Parliament come and change it and make it into the different way, because it is now contradicting their views. That would not work in Namibian situation. But if it is a statute, that's where Dr. Itula is correct, that if it is a statute, Parliament still have that same level of authority with the Supreme Court to then correct the position of the society. You must remember that Parliament is there to stand for the society, what the society's views and policies. They actually champion the policies of the society. So what do they want? Namibia must be positioned as an African country. Yeah. And if you look at the subject matter of same-sex marriage globally, there are only 44 countries, last time that I checked, that has legalized same-sex marriage. And out of these 44 countries, one of the superpowers or developed country, which is also G7, Japan, is not. Its constitution last year it has made it clear that their constitution doesn't allow it. But yet, their fellow G7 members, they don't put pressure on Japan and say, you need to do this. This is a human rights issue. So you position yourself as a nation in the world, as what your nation want to be, you know, in this planet. So it's not a matter of actually copying from other nations. Yeah. It's a question of Parliament is the one that actually champions the directions of the population.
So just a quick, Doc, do you want to say something?
Well, just to add that South Africa is the only country in Africa that recognizes same-sex marriages. At the same time, the international law interpretation has got two things. The monastic approach, where you basically make the international law superior to your municipal law or your national laws, or the dualistic approach, where the state considers its sovereignty as much more superior and looks at the international law. If it's impinged upon the local law, then the local law survives. And this is where the point is this: that do we have in Namibia a statutory provision to be interpreted by our courts as valid in terms of same sex? Because common law must be built on the interpretation of statutory law, because the judges are not the sovereign. And supremacy of sovereignty is opposed to supremacy of the Constitution. It's two different things. If it was a constitutional one, Article 1.6 survives, that our Constitution is the supreme law. Therefore, we cannot go against it. But the Constitution is born out of our people. And we cannot amend the fundamental principles, because Article 131 prohibits that, including Article 14, when it says men and women. We can't change that and interpret it to mean same sex.
I hear you. That's why I want to ask you this question now, Doc, because I said... Please.
Because you see, South Africa is not just the only country in Africa that recognizes same-sex marriage, but it's also the only country in the world that has put that sexual orientation concept in their constitution. So that is very important.
Yeah.
The second issue is we shouldn't really argue around the terminology that we have used in the Namibian constitution in terms of men and women, which is plural, shall have the right to marry and form a family. And then you ask, why is it plural? This is actually coming from all the documents in international instrument.
Yeah.
From the Universal Declaration of Human Rights, they use the same concept, plural.
African Charter.
The African Charter, the same. The ICCPR, which is the Civil and Political Rights, the Convention on Civil and Political Rights, the same. Also, the Convention on the European Convention on the European Convention of Rights. So the same concept. And when you look at the UN Committee on Human Rights, which administer or observe the implementation of the treaty bodies on the Convention on Civil and Political Rights, they have looked at this concept already in 2002 in the Jocelyn case, when the Jocelyn partners challenged the New Zealand legislation, marriage legislation, that they are excluded because they were same-sex couples. The committee, the UN committee, they clearly looked at that provision and said this concept of men and women doesn't include same-sex or homosexual couples. Mm-hmm. So it is not really the concept in the Constitution which is a problem.
Yeah.
It is correct as it is. And how international law actually works is that if there are those who want to interpret it to mean that way, then they have to come up with an optional protocol that it indeed means. It's just the same thing, like, you know, the current provisions of the Civil and Political Rights Convention is that it doesn't allow it protects the right to life. But many countries still are party to that convention, but they still apply death penalty and say this is our interpretation on this concept, that we can apply death penalty when we follow the due process of the law. But the other members, they say, no, it's absolute. You cannot apply death penalty. But then they came up with an optional protocol against death penalty, on which, if you are a party to that one, then you cannot have death penalty in your country. So in my view, this is how actually international law operates. So because people have assigned to these conventions based on their understanding of the terminology and concept of this terminology. So you cannot come now later and say, no, you have signed it differently, you understood it differently. This is actually the current meaning. Yeah. Then the member states only comply with international law based on their submission and understanding.
Yeah, I understand. The question that I wanted to pose, in the interest of time, Doc, is that we seem now to have the two channels through which this judgment can be reversed at all is, according to experts, is Article 81 that allows the Supreme Court to self-correct if that is a correct framing of the word, or that Parliament passes a law that contradicts the ruling. The Legal Assistance Center, for example, said that, in fact, in my view, the law already contradicts that. So there's no point in going to Parliament again and enact another law that contradicts this ruling, because even the existing law already contradicts that. Is this, are we at a point of no return as far as this ruling is concerned, or what actually are the chances of it having to be reversed?
We created a chimera, we created this monster, and it's been created by their lordships, and we've got a big problem from it. In that someone has to approach his lordship, the Chief Justice, to say, on this basis, you need to relook on it. One aspect of it, as it happened in other jurisdictions, is there anyone who had a conflict of interest? Yeah. And I remember a case in Namibia, I think it's something to do with the Caprivi successions, where there was someone in conflict in the judgment. So if any of the judges is found to be in conflict of interest for the purposes of the judgment and the outcome of the judgment, then there will be grounds to do that. But we must remember Article 78, sub-Article 4, where the Supreme Court and the courts are actually empowered to regulate themselves and to be able to make their own rules. And the rules as yet as to under what circumstances can the Supreme Court go and revisit a judgment. That is going to be problematic. And you have to approach the Chief Justice. And the Chief Justice, who was party to and wrote the judgment, has to go back and say, I was wrong. That is going to take a little bit. And at the same time, you cannot be named Judas in Akasosua. You cannot be a judge in your own cause. So all those judges cannot go back in again and deliver a different judgment. We've got a problem there. We've got to get other judges in the Supreme Court, a full bench, to decide that. On the side of the Parliament itself, it needs to go through the Cabinet Committee on Legislation, because even in Article 63 sub 2F, where the Parliament itself can initiate a referendum on the basis of the will of the people, they can make a law to reverse that, because Article 81 says if reversed by Parliament, which means that lawfully enacted, and one have to underscore lawfully enacted. Now, the Parliament and the Supreme Court has been put at par with each other because of the use of the or, either the Supreme Court or Parliament itself. Then you can reverse it. The other thing that you can then use is that you need to establish for the Supreme Court to reverse it whether there was a conflict of interest in any of the judges in any way whatsoever. Or you can come to Parliament. But in Parliament, you need to make sure that Cabinet approves an act of Parliament and the President assents to it. But to do that, the Cabinet Committee on Legislation, chaired by the chairperson, or the Minister of Justice, alongside with the Attorney General, need to supply the necessary legal framework for it. And then it needs to be approved by Cabinet and come to Parliament, and then Parliament approves it, and then it's signed. Now, the judges themselves were 5. They relied on the principle of Namibia's pillars of democracy to make that judgment with the dissenting voice of Mainga. Democracy operated there, but you need to read paragraph 103 of the judgment very carefully, in which the judges says that the representative of the people, even if they in their democracy and in the majority go and overturn this, we will still have to look at the constitutionality of that decision and overturn it. However, Article 81 does not provide for a vicious circle. The finality of the judgment will rely on Parliament, the will of the people. If Parliament says we will pass a law against this same-sex explicitly now, not implied in all the other laws, then that will stand as the law for Namibia, and the common law principle in the judgment will be done away with. Because once they've done that, and anybody takes it to Supreme Court to challenge its constitutionality, the Supreme Court no longer has got powers to reverse the decision of the sovereignty, the supremacy of the sovereignty of legislation, which in terms of Article 44 is in the hands of Parliament. So the Namibian people need to be very careful as not to be carried away by emotions. And I know that the bishops have written a letter to His Excellency the President. The President is not mentioned in Article 81 either. Although Article 30, that makes the President the custodian of the Namibian Constitution, somehow has got a degree of leverage to influence the decision. The prohibition in the Namibian Constitution of not interfering with the judiciary, it's saying do not interfere with the judges, not so much interfere in their judgment. So as the custodian of the Namibian Constitution in terms of Article 30, because it's the only oath that is an article in the Constitution, the President has got a certain impact on it. But Article 1.3, separation of powers, bars him from interfering with respect to His Excellency the President Dr. Hage Geingob. So the Namibian people need to be very careful how we educate our people for them to exercise their sovereignty even through a referendum.
I'm giving you the last throw of the dice, Basilius.
Okay.
But I know you want to react to this, but the one thing that I want to quickly ask you, we have 1 minute left, is there's talk of a referendum. In the human rights space, people would say you can't subject the rights of the minority to the decision of the majority, that somehow if the majority can deny me a right just because I'm in a minority, that it is a contentious issue. If you can summarize that for me quickly.
Yeah, that is what I said earlier on. There are freedoms and rights. Yeah. Rights are something that needs to be recognized. And you need to ask the question, because let's just confront the elephant in the room, same-sex marriage. Is it a legal issue or a social issue? So marriage is a social institution. So obviously it's a social issue. So therefore, in terms of our law, Article 1, Article 3 there, I think, says power shall vest in the people. Yeah, therefore, and it goes on when you read the Constitution, Article 132, that referendum may be conducted on subject matter of this nature, that affect the whole population. And it will be regulated by Act of Parliament. And that Act of Parliament is the Electoral Act. Section 119 talks about the President may call for a national referendum on any subject matter of national interest. And that is actually what happened in the first country that recognized same-sex marriage, which is Northern Ireland. But if you look at this issue, this is why the current Honorable Court, Supreme Court, did not really venture into the whole subject matter of same-sex marriage, because they are aware that it is not in their domain to decide on this issue, because they are not really the competent authority to determine that is actually the area of the Parliament to deal with, either through the debate or through popular vote. So I think we need to do a little bit of homework as how it's done in many countries. I know that in other countries they have legalized marriage through interpretation of their existing constitution, yeah, which is fine, but our constitution is very different. Yeah. So from any other constitution on the planet.
I have to stop you there, but I wish the conversation could continue, because it is perhaps the most enriching conversation I've had, not even one that I'm directing myself, but just that I've heard since this judgment came through. So Dr. Itula, thank you very much for making time, really. Bas, thank you for making time. We'll talk
thank
again.
You very much.
Yeah, we'll talk again. Sure. Very good. Yeah. That was tonight's show with Dr. Panduleni Itula, President of IPC, as well as Basilius Dyakugha. Sorry, he is Ombudsman of Namibia. Thank you for watching.
Thank you.